So we've been talking about over the last couple of weeks motions in limine, and you know from our discussions that motion in limine can be filed at any time, ideally before trial and ideally in writing. But that's not to say that they can't come up during trial, and it's not to say that they can't be oral. But we have a couple of different steps and a couple of things that you should include when either you sit down at your laptop and you write one out, or when the court holds oral argument on a motion in limine. The things that you have to put before the court and should make part of your written motion or part of your oral argument. And there's 4 different parts. The first is make very clear who you are, who you represent, in the context of the case. You can do that very quickly. Wes Porter, I represent the plaintiff. This is a medical malpractice action. Right? That may be enough to get the court into who I am, what side I'm coming from, and the nature of the case, so they remember. And you can give more specifics should you see fit. The second step is getting right into what is the evidence at issue. If you are filing a motion in limine, if you are arguing a motion in limine, you're talking about some evidence, likely that the other side wants to put in a trial, or that you believe the other side will put in a trial. Your motion in limine is likely to exclude, but it can be to admit. But either way, there is evidence at issue, and you should be direct and explicit about putting that evidence before the court. I'm Wes Porter. I represent the plaintiff in this action. This is a medical malpractice case involving bacterial meningitis of a young baby. The evidence at issue is a statement by the doctor in this case, and our objection is hearsay to it. Right? So I've put out who I represent, I've isolated the evidence, and I've previewed what my objection is, that it's going to be based on hearsay. The next step, after I say who I represent and after I introduce the evidence, is going through the analysis, actually taking them through why, under the rules of evidence, or under the policy behind the rules, or under the case law interpreting the rules, I win this evidentiary discussion, I win this evidentiary argument. So I've introduced the statement, I've said it's going to be a hearsay statement. Then, a lot of times, and most times, our argument will be settled on the rules. Our argument will be based on, this is what the rule says, this is the evidence, this is what they're trying to do with it, Your Honor, you should exclude it. In some instances, it's important to talk about the policy, the advisory committee notes, or some other policy statement as to why we have a hearsay rule, why we have the rules against character evidence. Lastly, when I say case law, appreciate that we're at a trial court. And sometimes persuasive to a trial court on an evidentiary issue is how other trial courts dealt with similar facts. And it doesn't have to be in a published case in another trial court level decision. It can be the judge down the hall dealt with a similar facts and similar case and similar evidence in this same way. Or you, Your Honor, in an earlier day, in an earlier case, handled it this way. Persuasive arguments through case law can be other trial courts, but it can also be other judges in the building or even that judge himself. Lastly, go to the remedy. Make sure that at any point during your written motion or during your oral argument on a motion in limine, you talk about the remedy. And the remedy is what you should do with my objection, and also, therefore, what happens to the evidence. So, Your Honor, based on my hearsay objection as to the statement from the doctor in this case, my objection should be sustained, and we should exclude that statement from trial from the doctor. I'm explicit about what I want to happen. I want you to sustain my objection, and I'm explicit what that does to the evidence. The statement in its entirety should be out at trial. So go through who you represent and the necessary background of the case, introduce the evidence that's at issue in your motion in limine, then go through your analysis, and it could be one paragraph, it could be a couple sentences, or it could be a longer discussion in your motion or at oral argument, and then finish always with the remedy and what you want the court to do on the motion.